Good morning, this is your Kelso Report for Tuesday, February 19th, and I'm your host, Clark Kelso. We have only two cases this morning. First, a Ninth Circuit decision involving the extraterritorial application of California state antitrust law. And the second, involving the tort duty to rescue doctrine. Let's begin with the Ninth Circuit. The Due Process Clause places a limit upon one state applying its law to out-of-state conduct and injuries. The question is generally stated as whether it would be arbitrary or fundamentally unfair to apply a state's law to the conduct in question. The Ninth Circuit faced this issue in the context of the application of California antitrust law to an alleged global conspiracy by LCD panel manufacturers to fix the prices of LCD panels sold, among others, to manufacturers of mobile handsets. Pretty much everything that all of us have bought over the last 6 years. The precise issue was whether plaintiffs who were indirect purchasers of the LCD panels could recover. Under federal antitrust law, indirect purchasers generally lack standing. But under California law, indirect purchasers may still sue. The issue in AT&T Mobility versus AU Optronics was whether California law could apply to out-of-state sales. The Ninth Circuit held that California law could apply, consistent with Due Process Clause, because the underlying conduct in this case involves not just the indirect purchase of price-fixed goods out of state, but also the conspiratorial conduct that led to the sale of those goods. According to the court, to the extent a defendant's conspiratorial conduct is sufficiently connected to California and is not slight and casual, the application of California law to that conduct is neither arbitrary nor fundamentally unfair, even though the sale took place outside of California. And therefore, the application of California law does not violate the defendant's rights under the Due Process Clause. Next, we have a duty to rescue case. Now, as everyone should remember from first-year torts, there is generally no duty to come to the aid of another. There is no duty to rescue. This rule applies even to public sector agencies whose job is to protect and aid, such as police and fire. A good example is found in the 5th District's decision last week in Greyhound Lines versus the CHP. The case arose out of an early morning collision between a Greyhound bus and a disabled sport utility vehicle on Highway 99. The SUV had been involved in a one-vehicle accident probably 3 minutes earlier and had come to rest on its side, blocking at least one lane. The bus collision resulted in the deaths of 3 bus passengers and the 3 occupants of the SUV. In the aftermath of this collision, Greyhound was sued for damages based on its alleged negligence. And in response, Greyhound cross-complained against various cross-defendants, including the California Highway Patrol. Greyhound alleged that CHP was negligent because the CHP 911 operator failed to enter the code for lane blockage, and thus the CHP response was unnecessarily delayed. The 5th District affirmed CHP's demurrer, explaining that law enforcement personnel, including CHP officers, have no duty to come to the aid of another unless a special relationship exists between the injured party and the officers. Such a special relationship arises if an officer's affirmative act creates the peril or contributes to, increases, or changes the risk that otherwise exists. But here, no special relationship existed between CHP and the injured bus passengers, and accordingly, there was no duty and no negligence. That's it for today's Kelso Report. Have a great day in the law.